The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, the 27th of January, 2016, opened up with gold at $1,120 an ounce, silver $14.48 an ounce, Texas crude $31.45 a barrel, and Bitcoin is currently sitting at about 395 U.S. currency. Today in history, Thursday, January 27th, 1825, the U.S. Congress approves Indian Territory in what is present-day Oklahoma. This cleared the way for the forced relocation of Eastern Indians, known as the Trail of Tears. In recent news, the Vatican announced over the weekend that Pope Francis will be visiting Sweden later this year to mark the 500th anniversary of Martin Luther's writing and posting of the 95 Theses on the front doors of All Saints Church in Wittenberg, Germany, October 31st, 1517. Amongst other points, Luther primarily wrote argumentations against the Roman Catholic theology of indulgences, essentially the selling of forgiveness from temporal punishment from sins for money, a practice still upheld by the Church. On October 31st of this year, Francis is set to be at the southern Swedish city of Lund, where the Lutheran World Federation was founded in 1947. While his predecessors have visited Protestant churches, Francis has come under criticism from traditionalists and conservatives within the Church, who accuse him of sending conflicting signals about interfaith relations. Catholic traditionalists have accused Francis of making too many concessions to Lutherans, since both religions will be using Luther's Common Prayer during the 2017 Reformation commemoration services being held jointly between the two churches, which they say excessively praise Luther, who was historically condemned as a heretic and excommunicated. Pope Francis has made ecumenism one of the main themes of his papacy, considering he has already visited the Lutheran Church of Rome, the Waldensian Protestant community in northern Italy, Rome's Jewish synagogue, and is soon due to become the first pope to visit Rome's mosque later this year. Marvin Minsky, a pioneer in the field of artificial intelligence at the Massachusetts Institute of Technology, died Sunday at the age of 88. Minsky viewed the brain as a machine whose function can be studied and replicated in a computer, and he considered how machines might be endowed with common sense or artificial intelligence. Daniela Rust, director of MIT's Computer Science and Artificial Intelligence Laboratory, said that Minsky helped create the vision of artificial intelligence as we know it today. This was your lowdown for January 27th, 2016.
You gonna do? Yeah. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? When you were 8 and you had bad traits, you go to school and learn the golden rule. So why are you acting like a bloody fool? If you get hot, then you must get cool. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? You chuck it on that one, you chuck it on this one, you chuck it on your mother and you chuck it on your father, you chuck it on your brother and you chuck it on your sister, you chuck it on that one and you chuck it on me. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? Nobody now give you no break. Police now.
Okay, howdy. This is Randy Kelton, Deborah Stevens, Rule of Law Radio. And on this Thursday, the 28th day of January, 2016. And we have Jeff on the line. He's going to be up in a minute, Jeff from Mississippi. But tonight I was going to go over something that I found rather interesting. I've been designing a set of presentations that I will be putting together into a one long seminar or one long presentation. But it's a rather complete redesign of the living mind. So I've been talking about some of this already, and I'm doing some intermittent shows to where I'm developing some of the pieces for it. And in going through all this stuff, I came across something real interesting. How to tell people when people were lying. And I had this article for quite a while, but I was busy doing what I consider to be more immediate stuff. so I didn't get to it. But yesterday I decided to look at it, and I found it very interesting. They use this article presents information from neurolinguistic programming from Paul Ekman. Ekman, if anybody has ever heard of the program Lie to Me, that was a program about the star characters were deception experts. And they would get hired to tell when people were lying. And it was a very well done program because they demonstrated the technology. And the technologies they demonstrated were based on a researcher named Paul Ekman. And I think I have just about all of his works, all except for one of them. And it was like $300, so I didn't get it yet. And it was a little bit too scholarly a white paper to be of any value for what I'm doing. But I find a lot of his techniques in there. So I was going to go through some of the ways to tell if people were lying. And first thing you do in order to tell if someone's lying or not, it's not something you can just do. In that you can't just look at somebody and say because he does a shoulder shrug or a particular emblematic gesture that he's lying. First thing you have to do is calibrate. In neurolinguistic programming, they would call it calibrate. But here they call it developing a baseline. You pay attention to the person and notice how they use their voice, tonality, cadence, pitch, tone, how they hold themselves, how they move, whether they use hand gestures, don't use hand gestures. Get a good feel of how they present themselves in their environment. And in order to, once you start looking for deception, the first thing you look for is a change in the baseline behaviors. The pitch of the voice changes, the cadence changes, or they weren't using hand movements and they start using hand movements. Anything that appears to shift them out from their baseline. And then you of course, pay attention to the context. If they're talking about being chased by a robber with a pistol, their baseline is likely to shift. But other than that, if they're purportedly telling you facts about something and their baseline shifts, now you start paying a lot closer attention. And of course, one of the things you pay attention to is tonality. As a rule, when someone is lying, their pitch of their voice will increase somewhat, or they'll speak somewhat faster. So I'm not going to go through much on baseline. Here we go. Continuous reactions. Verbal communication. Here we go. So we look at, most when we communicate with someone, about 20% of what we actually communicate, we communicate by voice. 80% of the information that goes back and forth between two people are communicated in nonverbal ways. Facial expressions, asymmetrical facial expressions. There's a guy who was one of the developers of neurolinguistic programming, Richard Bandler. And always I had a problem with him. I've studied body language for a long time. And when I look at Bandler, you look at his face, and one side of his face is different than the other. If anybody has ever looked at body language, one of the things they do in body language is they'll take a full-on facial photograph, then cut it down the middle. They'll take two photographs, cut them both down the middle, and then they'll take one photograph in mirror image so that they can cut them in half and put the two left sides together as if there were a left and a right. And then they'll put the two right sides together. You would be amazed at how different the two faces look because it's the asymmetrical nature of the face. And there are a lot of facial expressions that will tell you if someone is trying to deceive you. There are 5 basic expressions that are essentially universal across all cultures. So we find them here. I've been verified. I studied this a little more so I could present it a little more quickly, but the 5 basic are disgust, fear, anger, I don't have the other one in front of me. These are the main ones that we look for if we want to see if someone's lying. And Dr. Paul Ekman speaks to these as micro-expressions. While they're micro-expressions, we as natural speakers of the language, we tend to recognize when someone gives us a facial expression. If all of the muscles of the face tend to pull together, that's disgust. And if someone is telling us something and he doesn't believe what he's saying and he doesn't think much of us for asking, we'll get a micro-expression of disgust. If we've asked him something that he doesn't want to answer, we'll get an anger expression. I'm probably not. I need to study this a little more so I can deliver it in a little more coherent way. I'm not doing a good job here. Heck with this. I need to do my homework. I thought I could present it more coherently, but I'm going to have to study it a little bit more. We do have a caller. I'll probably do better with a caller than I'm doing with this presentation so far. So let's go to Jeff in Mississippi. Jeff, save me. I've screwed up the first part of this show.
Yeah. Hey, Randy, thanks for having me on the show.
You are welcome.
And I've got a general simple question, but I'm really getting hung up on it. And that is that when I try to type up, I'm typing up some complaints right now, and I've heard for a long, long time, especially from the Patriot movement, that I need to change my language around, and I also need to change how I type things. In other words, don't type in all caps, put it in upper lowercase. Don't use words like plaintiff, use words like claimant. But my problem is that I've done that, but now I'm starting to receive paperwork back from the court, and they're changing it back to plaintiff and putting it back in uppercase anyway. So that was my number one question.
Okay, let's go to that first.
Is that a big waste of time? Or?
So far as I know, uppercase names in court means nothing. It's just their style.
Okay.
They have a style of producing documents. In uppercase is a way to highlight the name. If you got the name in uppercase on a document, it's easy to find. But all this patriot mythology about your uppercase name being your straw man name or your public name and your lowercase name being your private name, I can't find anything in law that supports that. I do have some people purporting to give me stuff in law, but what they give me is a bunch of garbage. So I have never used all uppercase for my name. It's not the way I write my name. And I've never noticed the courts ever changing it. So if this court it's just stylistic.
Okay. So I don't need to get hung up and all that.
Yeah. If you're writing criminal complaints, there really are no hard and fast rules other than one or two. In Texas, a complaint must run in the name of the state of Texas, the name and authority of the state of Texas.
Okay.
And it must have the date of the offense cannot be prior to the offense. If the date is prior to the offense, that's not something that can be fixed.
Oh.
And complaint will get trashed. If it doesn't run in the name of the state, and every complaint I've seen pretty well runs in the name of the state, then it's not a complaint if it doesn't run that way. Hang on, we're about to go to break for Randy Kelton with Real Radio. Our call-in number, 512-646-1984, and we still have our fundraiser on, so go to Logos Radio Network. We'll be right back.
You are listening to the Logos Radio Network, LogosRadioNetwork.com.
Look what we get. We asked the question. I wonder what they're hiding. Don't have the answer. They're not abiding. We asked the question. Look what we get. And they don't have the answer. Slope and slip and slide. Them a talk about issues passy, Lord, how they want we to take it easy. Them a talk we too politically and them getting mad and angry. But them not standing up and fight for the freedom and be free. And they like the
them love slavery and get handout from the government. We ask the Christian, don't have the answer. We ask the Christian, and they don't have the answer. Tyranny, them a tear you, them a tear me, Lord, them a tear the country.
Okay, we are back. Randy Kelton, Louisville Radio, and we're talking to Jeff in Mississippi. And we're talking about essentially style. You're writing a criminal complaint and you were concerned about all uppercase names. You put it up or lower, they changed it. As far as I can tell in law, that means nothing. I've got Eddie Craig on. Eddie, have you come across anything to where your name in upper or lower case makes a difference?
No. And generally speaking, what I believe he has originally said to you is when he's saying the courts are changing it back, what you actually mean is that the stuff they send you still has it in uppercase. They're not changing your documents. They're just not changing theirs. Is that correct? Okay.
Yes.
That makes no difference. I've never seen that make a difference. Okay.
Okay. Now, what about terms like plaintiff, defendant, claimant, and wrong?
It doesn't matter what you call yourself. They're going to always refer to you unless you ask for a motion in limine in court while you're in front of a jury or the judge to be addressed differently. Their paperwork from them is going to always reflect you as the defendant. You can put whatever you want in your paperwork, calling yourself whatever you want. You can call yourself Grandmaster B if you want to.
Mm-hmm.
Okay? But for referential index, they're going to always refer to you in a way that's familiar to their style, as Randy put it.
Yeah, okay. And in a criminal complaint, I always put complainant. I've just looked at one today where somebody had called himself a defendant. And because of the context, so this was not a reply to a motion or a motion in a criminal case or a civil case. This was a criminal accusation, and you're the one that's doing the complaining. So I tend to call myself complainant, and that's just for clarity. But other than that, in a criminal complaint is intended to be prepared and presented by an ordinary citizen. So they're not very stringent. There's not very many rules.
Okay, what about a civil?
Well, no, wait a minute. Are you talking about filing a suit, or are you talking about pressing charges? Because they're two different things.
I'm talking about filing a suit. I'm doing a civil suit, a Title 42.
Okay, then you want a civil complaint.
Uh-huh.
Okay, that's completely different than criminal, which I think is what Randy's dealing with here.
Yes, you're saying complaint, and I'm not thinking civil complaint. This is an original petition.
Okay.
Right? Yeah, in original petition, you are the plaintiff.
Yes.
Always. You don't care what they put in there.
Oh, okay. I am the plaintiff then.
Yeah, in a civil complaint, if it's your suit, you are the plaintiff.
Okay. Okay, I don't need to worry about claimant or wrongdoer or all that stuff.
Only in reference to them.
Okay. Well, now, and that's another question. Does that really matter? Because I've heard that, like,
You can call them defendants all day long. It isn't going to matter. If you want to create another name for them, you can do that, but you got to make sure it's throughout the document. But I recommend you stick with what they know, which is defendant.
Yeah, you put their name in, and then put in parentheses, hereinafter referred to as. You do the same thing for you. Your name, hereinafter referred to as. And it don't make any difference what they call themselves or what they say. As concerns the immediate document, you have defined what this term means, so you don't have any issues with that.
Okay.
And you might listen, because Eddie and I are going to talk about some issues, and we may talk about some documents he's producing, and I'd like to talk some about style that really doesn't go to like the blue book styles. Like the standard, there's a standard blue book that has how you style citations and how you style different things. I wanted to talk about style as concerns human beings and how they read and understand the written word, so that you prepare your paper in a way that makes sense to them. One primary thing is footnotes. I really hate footnotes, because to read a footnote, you have to drop out of flow. So if a footnote is something ancillary, that just something for reference, then I'll put a footnote in. But if I make a statement that the law says this or that, I don't want to put a footnote to where that's where I have that section of what the law actually says. I want to put it in a quote right underneath where I'm at, so that the reader can read the quote and stay in flow and not have to stop and go to shift gears to go find the footnote and then read the footnote, but then they've dropped out of middle flow. So I generally always put it right under, and I always shrink both margins, change it to single line, and drop the font by 1 or 2, generally 2. So stylistically, when the reader gets to that quotation, he may have to look at the first one and realize this is how I do quotations. But after that, when he sees that particular change in style, he's going to know this is where my narration stops and where the quote starts. And then right down here is where the quote starts and my narration starts again. Yeah. Because I've seen quotes put in the body of the text, and sometimes it's really hard to tell where the quote starts and the narration begins. So you can figure it out if you read the sentences carefully and will check for the quotation marks and make sure that this quotation mark's not starting another quote, but you have to shift out of flow to do that. So this is the kind of things we probably need to do a whole show on stylistic elements.
That's what I'm getting hung up on. My last question, and this may seem petty, but it may be important. I've been reading some Title 42 complaints as examples, and some of them make the statement that they are seeking declarative and injunctive relief. And my big question is, I kind of know what declarative relief and injunctive relief is, but if you're doing a Title 42, how would that really flow into that?
Well, declarative would probably be something like you ask the court to enter a declaratory judgment on, say, a document that you filed or a document that they're using. You want them to declare that this document is either valid or not valid. Injunctive relief, then you're going to go to asking the court to direct the other person to do something or not to do something.
Mm-hmm. Now, if you're suing somebody for money, I mean, really, what are you asking the court to do other than get? Then
you may have declaratory, you may have injunctive, you may have
damages, punitive.
Yeah. Then you'll go to tort and causes of action.
Now, your declaratory, you can also be seeking a judicial opinion about a particular statute or interpretation of statute and so on and so forth.
I get that, okay.
You're asking the court to make a minor ruling on something that then becomes res judicata. You get the court to say that he takes judicial notice of the existence of this document. He doesn't have to take judicial notice of the facts in it, but then this document is now officially in the record. It's never going anywhere.
Got it. Okay. I sure appreciate it. I'm done, fellas, and I'll call in next week.
Okay, thank you. This is Randy Kelton, Eddie Craig, Deborah Stevens, Riverlaw Radio. We've got our fundraiser on, so make sure you go to Logos Radio Network and Randy's Beer Fund.
Children conceived through fertility treatments are more likely to suffer serious birth defects than babies conceived naturally. I'm Dr. Catherine Albrecht, and in a moment I'll have details on a groundbreaking study on the risks of fertility treatments.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
These days, childless couples are turning to fertility clinics in record numbers, but a new study finds the risk of birth defects in babies conceived through fertility treatments is significantly higher than average. After reviewing 300,000 birth records, researchers found that 8% of fertility babies suffered from heart, genital, kidney, brain, and lung problems. That's 40% higher than babies conceived naturally. What's more, the risk of birth defects tripled when mothers use clomiphene citrate, a drug that induces ovulation. With millions of babies born each year through fertility treatments, it's about time doctors began telling their patients about these risks. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Live Free Speech Radio, LogosRadioNetwork.com.
Yeah, Mr. Officer, you're taking the law in your hand. Won't you follow the law of the land? I don't understand. Your job is to protect and to serve. not beat and abuse. Officer, when you gonna stop abuse your power? 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 So please, Mr. Michael, teach officers not to abuse their power. Send a request to the leader, the captain of all officers. Tell them to uphold the law, and please don't abuse their power. They beat and they beat and they cheat and they cheat and they like every hour. So Mr. Officer, please stop abusing your power. You pull me over and tell me to be silent, sir.
Okay, we are back. Randy Kelton here with Eddie Craig, and we have a very, very special guest that we always treat with kid's gloves because he is quite aged. He is so old, he's older than me. And like I always say, I got dirt in my front yard that's not as old as me. Hello, Jeff Sedgwick.
How are you, Mr. Randy?
I don't have my hearing.
Are you not here? Hello?
Yeah, we hear you. Go ahead, Jeff.
Okay. My call was basically in response to Jeff in Mississippi. He was talking about the Patriot community, and my experience of the Patriot community fits with a Mark Twain quotable quote that goes like this: "It isn't what you know, don't know rather, that gets you into trouble. It's what you know for sure that's wrong." He is filing under Title 42, which is law. He needs to file his case in law, not equity or common law, but in law. And to do otherwise, it's basically going to cast aspersions on him from the judge, and the judge is going to look at him with a very jaundiced eye. The other thing is he needs to check the rules of federal procedure, and he also needs to check the local court rules, and just to dig a little deeper within the local court rules, check to see if the judge he's going before has his own set of rules, so that when he writes his complaint, it matches the rules, and he stays inside the good graces of the court. And that's about all I really had to say.
Well, just explain to him real quick what you mean by in law, Jeff.
Oh, God, that's a 4-hour soliloquy there, Eddie.
Okay, well, do you have some place to send them for reference to look it up then?
Well, when you're going into court under law, you're citing statutes. What statute did they violate? Not some equity where things are where the situation didn't break equitably for you. You had a deal where you were supposed to come out. Each one was supposed to come out with a certain benefit, and one person didn't get the benefit. That would be equity because you're not citing statute there. You're citing equity.
Right.
And if you're going to law, which Title 42 is law, you have to cite what statutes were violated and how they violated and what the penalty is for so doing. It is a comprehensive pleading.
Yeah, which in this case the statutes. Yeah, which in this case, if it's a suit against a public official, you would be citing something like Title 18 as the statute they violated, giving you your cause of action under Title 42 in law.
Something like that, or you start in with Title 42, 1983, deprivation of rights, and then bring in the criminal part where they perpetrated a crime, and in so doing, deprived you of your rights.
Right.
My question is, if I'm filing a RICO suit,
a what?
If I'm filing a RICO or a 42 U.S. Code suit,
1961?
Is it mandatory that I use the term in law, or is the suit filed in law when I file it making claims under statute?
It's in law when you're making claims under statute. But
I don't have to say I'm filing in law or in equity.
No,
it just is what it is.
That's demonstrated by filing under statutes. If you're filing in RICO, you have to file under two statutes. One is 1961, where there's an ongoing enterprise, and the second, what the violation was the enterprise was perpetrating.
Yes. So by citing the
both
statutes,
those statutes are RICO statutes.
Okay, so you filing in law is not something like a header on the document or something, some specific words you have to put in there.
No.
It is a style of preparing the pleading.
No, it's actually contained in the venue statement.
Wait,
Let me
I
give you,
missed
for
that.
instance,
In
here.
the what statement?
Jurisdiction statement. This particular jurisdictional statement here. This court has jurisdiction under 15 U.S.C. 1962 KD et sequis. Also 47 U.S.C. 227 B3 and 28 U.S.C. 1331 and 1337. Those are your at-law statements. That's at-law jurisdiction.
Okay. Now I got it. Now I understand where you're going.
Okay.
And I hope Jeff is listening. I would think
I
that
hope so,
the
too.
jurisdictional statement would be very, very important.
Oh, it is.
Yeah, it's
It very
kind of like
much is.
towing a trailer without a ball hitch, Randy.
Yeah.
Well, something you're readily familiar with,
You
right?
mean trying to lash it
Yes.
to the vehicle with a chain?
Or a stick.
I'm real familiar with pulling vehicles with chains and pulling them with, yeah, I've had lots of wrecks doing that.
Or how about a rope?
I break those. I had
All right,
someone
that's
told
what I
me
had to
on a motor
contribute.
scooter once.
Uh,
With me
Jeff,
holding a rope.
my.
You know, when they
Right.
shift to second gear, they can snatch you right over the handlebars, and that motor scooter will run right over you. That hurt.
I
And it'll
bet.
snatch you over the handlebars before you can turn loose of the rope. Anyway,
Yeah, if you don't manage to jerk it up in the air and throw you off backwards.
well, this one snatched me over the handlebars, and I had tire marks up my behind where that thing went over me. It was not one of my
Right.
better days. Okay.
Well, that was what I had to contribute to Jeff in Mississippi. So thank you for the opportunity.
Thanks, Jeff.
Good night.
Night.
Okay, thank you, Jeff. Now we're going to go to Tommy in Texas. Hello, Tommy. What do you have for us today?
Hey, good evening, guys. First of all, let me say I did purchase that jurisdictionary course through the Logos Radio Network site. So
Wonderful, wonderful.
yeah. I've got a question regarding loan assignment or mortgage assignment or promissory note assignment. I have a first mortgage. I have a written agreement with, but they transferred they assigned the servicing to another company, and they sent me a letter saying that it was going to be assigned. The other company.
Okay, hold on. You're breaking a cardinal rule. You're using pronouns.
Personal pronouns. Yeah. Okay.
Tell us who they is so that we don't get the references mixed up.
I apologize. The first mortgage company sent me a note saying that they had reassigned the mortgage servicing.
Okay, how old is your note?
It was signed on November 25th of 2015.
Oh, okay, so it's a new note. So I won't ask that. The second question was going to be, is the company still in business? But if it's 15, then that won't be an issue.
The first company, the originator, is still in business, and they did, in fact, record the deed in the land records.
Did they record an assignment?
No, that's why I'm calling. The new assignee, the second mortgage company or new servicing company, has not filed a record of assignment.
Okay, they may not have to, and I'll explain that when we come back on the other side. This is Randy Kelton here with Eddie Craig, Real Law Radio, and our fundraiser is still on, so go to Logos Radio Network and look over our advertisers. And if we have anything there you can use, if you purchase it from us, it'll help us support this station and get you in our drawing.
Easy.
Okay, we are back. Randy Kelton, Eddie Craig, Rule of Law Radio, and we're talking to Tommy in Texas. And what has apparently happened is they've merely changed the servicing. In the securitization world, what is actually sold is not the note or the deed of trust or any of that. This is factoring. They factor the accounts receivable, and your note constitutes accounts receivable. And they sell the right to receive the payments. So that's what gets sold. And generally, the lender will keep the servicing rights. The banks actually sell the servicing rights to different companies. So what they've done here is transferred the right to service the note to somebody else. That doesn't go to the deed of trust or the note either. So under the Real Estate Settlement Procedures Act, they have to give you notice, but they don't have to file that in the public record.
Okay, because they didn't, and I was wondering, would that hurt in any way my legal standing if I didn't challenge that fact or put
No, that won't hurt. That was a necessary. They gave you the necessary notice, and that's giving you notice within 30 days. And they have to tell you that if you still send your payment to the other company, that company will send it to us, but you're supposed to send your payments to us. And that's about it. But it doesn't involve a change in holder status of the mortgage.
Okay. Well, then I feel better then. Okay. I just wasn't sure. And I couldn't find it. I didn't know if it was a requirement to record that or not, but I guess it is not.
No, not that one, because that doesn't affect holder status. So there is no actual requirement to file. However, if you fail to file, there is a consequence, and that's 13.001 Texas Property Code says that any claim against real property not properly acknowledged or proven and filed in the public record is void as to the holder. And every state I've looked at in the union has a similar statute. So the only state I know of where it's statutory to file is Pennsylvania. Every place else, it's optional. But if you don't file, then you don't have standing to enforce your note. And this is one of the biggest claims people are making against the banks, is you don't have standing to collect. Okay, does that make sense?
It makes a lot of sense, yeah. Okay, hey, look, I appreciate what you guys do, the sacrifice that you make. And everyone out there, listen, let me tell you something. You guys need to purchase these men's material because it will give you knowledge. And knowledge is power. I am a direct beneficiary of that. That's not just a statement you see on the bottom of someone's email or on someone's page. It's actually true, and I've lived it. And I've got 4 wins in court right now, 2 in traffic and 2 in family court because of these men. Thank you very much.
Appreciate it.
Wonderful. Yeah, I just had someone I was talking to today had filed Eddie's motions in a court in Rockwall. Rockwall is a east suburb of Dallas. And the guy in front of him had exactly the same motions.
Oh, man, incredible.
So that's good. This is getting around. Okay, thank you, Tommy. Now, Eddie has got a document we want to discuss, but Eddie, you Skyped it to me twice, and your Skype is saying this file isn't available. Can you email it to me so I can...
Well, I can certainly try real quick, see if it does any better.
Okay, while you're not as old as me, so you can multitask.
I can certainly try. I'm usually pretty good at that aspect of things.
Kind of give us a brief on what the document is.
Okay, well, this is actually a case out of the state of Washington Supreme Court, but it creates an interesting premise for my document challenging the constitutionality of the amended or the recodified Transportation Code Bill SB 971 from 1995. Now, the document's emailed to you, Randy, so you should have it. But what I'm looking at in this case brings up a very interesting perspective that I'm actually expecting the state of Texas to try to run to. And because of that, this is what I wanted to discuss with you about how this is going to play out if they do it here. Now, basically, this case is in re Self, and that's SELF versus Ray, RHAY, 377 Pacific 2nd, 885. Now, in this case, it's dealing with an unconstitutional ordinance or statute. And in this case, they have this where this gentleman was challenging the constitutionality of an amendment to a statute of the state of Washington. And this is something that the state Supreme Court said. Section 35.27.020 of RCW, which is Revised Codes of Washington, as derived from Section 15 of an act providing for the organization, classification, incorporation, and government of municipal corporations, laws of 1889 and 90, page 141 is amended to read as follows. And then it puts this into the amended language. In this respect, the 1951 legislature was following its own unconstitutional device for amending a section of an act in disregard of the specific constitutional mandate. The act before us does not purport to amend a section of an act, but only a section of a compilation entitled Revised Code of Washington, which is not the law. Such an act purporting to amend only a section of the prima facie compilation leaves the law unchanged. So here is what I am expecting the state of Texas to attempt to do in relation to my challenge to SB 971's alteration of Vernon's annotated civil statutes into a single codified transportation code.
Okay, hold on. Back up just a little bit.
All right.
Explain about the 1925 code as concerns changes or alterations.
All codes in Texas are based upon original acts of the legislature from 1925. If you actually read Vernon's, the publications of Vernon's, right inside the cover page, there's a title page, and inside the title page there is a certification page from the Secretary of State. The Secretary of State certifies on that certification page that all the statutes in that code are compliant with the original act itself. None of the current codes have that. None of them. They are all recodifications of Vernon's without the certification. And we know already from some of the stuff Randy's read in my paper why they didn't certify those new recodifications. Because they greatly altered the recodified sections of statute from the originals in Vernon's, despite telling the legislators and the public that they were not doing so. They put that in the language of the title of the bill, which is supposed to tell the public and the legislature what its real purpose is, and they put it in the beginning of, or 1.0001 or 001 of the codified version itself that said there was no substantive changes to the statutes. That was a bald-faced lie from day one. Now, the 1925 law is what the legislature originally passed that all these codes are based on, whether it be the Vernon's prior to 1995 or the recodified transportation code as it exists today and all of its amendments from 1995. Now, what I'm expecting the state to do is to argue that since I'm challenging the constitutionality of SB 971 in its entirety, that they're going to say that the challenge is moot because the Constitution does not apply, because the underlying law has not been altered and the statute itself is not the law. Therefore, the constitutional limitations don't apply. Now, if you actually read the language of the bill and then look at the rules regarding that, the Texas Constitution applies to the bill. It doesn't apply to the law created by the bill, except in certain provisions. But in relation to a bill, everything I'm arguing relates to the bill, not the existing law. And SB 971 is a bill. So this argument won't fly for them, but this is what I'm expecting them to pull. If they turn around and say that the statute is not law, they have put themselves into double jeopardy with constitutionality. And here's why. Randy, can you tell me if a statute is not a law, what is the problem with you being charged in court with an offense against something that is not a law?
There's no claim. This court has no subject matter jurisdiction.
That's correct. And what does Texas law require in relation to a criminal complaint?
A complainant.
Well, not just a complainant. Let me read you something straight out of the Code of Criminal Procedure. Now, this is out of Article 45.019. This deals with justice and municipal courts, but it'll be no less true for any other court. And under 45.019, subsection A, a complaint is sufficient without regard to its form if it substantially satisfies the following requisites. Number 4 of those requisites reads, it must show that the accused has committed an offense against the law of this state, or state that the affiant has good reason to believe and does believe that the accused has committed an offense against the law of this state. All right, that's what I'm going to leave the setup at. When we get back, Randy, we can talk about that if you remember it over the break, and then we'll get into it.
I'll try to remember that long. Sometimes I'm able to. This is Randy Kelton, Eddie Craig, Rules Law Radio. We have the phones off for the moment. Once we're through this, we'll turn it back on. We'll be right back.
They want to chant down Babylon and burn down the whole nation. But to them operate the land wrong. I'm going to say Republican and them a scratch, man. Tell them I'm a libertarian. Them say we want to lose, but we want to win. Come rock and walk.
Chant love rule this time.
How what we say?
Chant for our wars.
What me tell them?
Chant down by, chant down by, chant for justice.
Okay, we are back. Randy Kelton, Blue Law Radio, here with Eddie Craig, and we're talking about the difference between the code and the actual law. You want to pick it up, Eddie?
Yeah. The issue here that I'm trying to clarify for the purpose of the argument in this motion is the state's attempt to say that the challenge to constitutionality of SB 971 isn't applicable because the statute is not law and therefore is not subject to those restrictions. Now, this puts them in a catch-22 from my perspective of how this would be argued. And the reason for that is because in Texas, the criminal complaint, as I was reading before the break, subsection 4 of Article 45.019A says that the complaint must show that the accused has committed an offense against the law of this state. So if the statute that they're using is not the law, and they're admitting that it's not the law, then they are admitting that they have knowingly prosecuted people under something that is not law. In other words, they've knowingly committed extortion, fraud, kidnapping, assault, aggravated assault, and murder on its face. Their only other option is to say that it is law, in which case the constitutional provisions I'm arguing invalidate it for being enacted in a manner that is violative of very specific provisions that it can't violate and be law. So either way, they're hosed. And that's my argument, and I want to see if Randy can force me not to stick to it.
If the state comes to court and files a document in the court wherein the state takes the position that the code is not law, that's collateral estoppel. They cannot come back later and say, oh, yeah, it may not be law, but we can enforce it. I can't see them doing that, because they would open an incredible can of worms.
Yeah, at this point, I can see the lesser of two evils for them being to treat it as if it is law and let it be declared unconstitutional, because at least they would have some sort of coverage for liability. When you look at the way the courts have ruled on this, if an officer acts in good faith under an act that's later declared unconstitutional, he can't be punished for his actions under the act prior to that declaration by a court. I've got a problem with that, at least as far as Texas is concerned, because the Texas Constitution does not set a period. If it's void ab initio, it's void ab initio. Article 1, Section 29 says that when an act is done in violation of the Constitution, it is void. It's not voidable. It's not later voidable. It is void. So I don't see how they can refuse to declare it void ab initio and take away that liability from these officers. Because if anything, the courts were absolutely required to understand the legislative intent. And yet, for decades now, they've used it in a manner that is completely outside of its stated legislative intent. Because the bill very clearly says in its title that the legislative intent is to create non-substantive recodifications of existing statutes relating to transportation. There's no quibble over the fact that the code itself regulates transportation as its primary subject matter, the governing subject matter. And yet, they've treated it as if transportation is irrelevant. I can't see how that could be anything less than intentional.
Well, of course not. They couldn't, 1925, they couldn't pass laws requiring or restricting you in your right to travel. The only thing they could pass laws concerning was commercial. And I read some articles recently about how all of this came about. And the licensing originally came about because in the 1920s, we were just getting trucks that could actually haul products, but they weren't very well constructed, and people were kind of jury-rigging their own stuff, destroying the roads and killing people all over the place. So they needed a way to get this under control, and they passed this commercial code. Sometime in the late 30s and early 40s, they began enforcing this code against everybody. And nobody raised a red flag. And so now they had the code to where they could enforce it against everybody. But the whole time it's been illegal. And the problem we have now is they making so much money doing this. that, everything's always about the money. The fight will be horrendous. They're going to fight tooth and nail to save all of this unauthorized tax they've been collecting. So how do we structure this so that if we get a ruling against us, if you get a ruling that says, oh yeah, this applies, that ruling can be taken and used in a way to disrupt the entire system?
Well, again, I'm using, in reference to this case, I am using the United States Supreme Court's rules of constitutional and statutory interpretation against the state. Because if it winds up in the United States Supreme Court, that's who's they're going to play by anyway.
Well, that's exactly. This should go to Fed anyway, because it's a due process violation, a federal due process violation.
True, and there is something interesting I have found of late too. It turns out that in July of last year, the Texas Supreme Court may finally have judges on it that actually bother to read what's written in the law for a change. And this was an occupational licensing case. It dealt with the eyebrow threading here in Texas. They made the cosmetologists and everybody else, the beauticians, they were raising all kinds of stake about the eyebrow threaders, and the legislature was trying to force them into acquiring a cosmetology license, which is 300 hours of training. Plus, they had to have a facility of X number of square feet and such capacity and blah, blah, blah. When, in fact, an eyebrow threader, not 1 minute of that 300 hours dealt with the occupation. Not 1 inch of square footage is required for them to do it because they can go to someone's home and do it. So all these requirements they were forcing on this occupation, the Texas Supreme Court said, it's ridiculous. You guys are getting way outside of your bounds. You're using established businesses to suppress new businesses to keep their profit margins higher. Not going to happen. But the part I found interesting about this occupational licensing case was the court's opening discussion on the needs for these licenses. One of the discussionary paragraphs contains a reference to you need a medical license to practice law in Texas. And then they go into, and you need a driver's license to zoom down I-130 outside of Austin. Now, why would the Texas Supreme Court make reference to driver's licenses in a case that is 100% about occupational licensing, and at the same time do so in conjunction with a specific occupation license, which is the medical? Well, there's only one reason. Because the driver's license itself is the licensing of an occupation as well. It's not there to make conversation, it's there to make a point.
Well, it's really clear in law.
Oh, yeah. No argument there. It's just not clear in the money-grubbing little cockroach courts that want to steal rather than follow the law.
So how do we construct a case so that the question we ask is such that if we get a ruling against us, it undermines the corpus juris? That's the only way we get a ruling in our favor. If shyster lawyers can take the ruling and use it in other places that will be more destabilizing than forcing the legislature to write new laws for travel. We can't license travel, but we can regulate in some ways how people travel.
Well, we can regulate the movement. Yes. Like, signage and lights and things like that at intersections for the public safety. That they can do. But one of the arguments I'm making in this is straight up, the argument by the state that licensing in Texas relates to public safety is an absolute joke. It's a complete joke. When you look at all the licenses that are issued, you will find that only those that are going into the specific occupational side of that, as far as they're trying to tell us you need one over here and one over there, they're different, but they're not. Everyone that goes into an occupation, truck driver, shuttle bus driver, school bus driver, taxi cab driver, all of those people must have specific hands-on training to go into that job. Yet anyone else applying for a license does not require 1 second's worth of training. All they have to do is walk in, take the written test, take the driving test. If they pass them both, they get a license as long as they pay. There's no other qualifications to train.
Wait a minute. My license is a chauffeur's license.
Really?
So
how would you have gotten a chauffeur's license when chauffeur's licenses don't exist in the recodification?
Well, it's considered a chauffeur's license in that it authorizes me to carry, I think, up to 8 people for pay.
Yeah, but see, that's another one of the issues between the recodification and the Vernons, and which is the part you read relating to the licensing. In relation to a license, the original Vernons recognized only 3 forms of license: operators, commercial operators, and chauffeurs. All of them were occupational, all of them. Now, the new code doesn't mention those licenses at all. It never did. They were not in the original SB 971, and they're not in any of the amended side of it. But I'll finish talking about that when we get back after this break. All right, folks. Go ahead, Randy.
Randy Kelton, Eddie Craig. Make sure you go to Logos Radio Network and buy everything on there. We need all the help we can get. And if you do buy one of those products, your name goes in a hat for the gun door. So have a look at the gun.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me. Well, ain't gonna fool me with that same old trick again. I was blindsided, but now I can see.
All right, folks, welcome back. This is Rule of Law Radio. Yes, it is Eddie Craig. I am coming on tonight for a little while with Randy. I ran into some issues that I needed to discuss openly, and he is the sounding board I have chosen for that. We needed to tighten the strings a little bit here lately, but we'll get with that later. In the meantime, there is something. As you know, we're doing the fundraiser, and we're trying to get money together for both the network and for the lawsuit and everything else. And as Tommy said earlier when he was on, the information we provide has value. It had value to him. It's had value to many, many others that have used what we provide to save themselves from a situation they otherwise would have lost whatever they would have lost in. But regardless of what that amount might have been, please consider the following. If you get into a situation where the information that we provide you saves you in that situation, all the money that it would have otherwise cost you to have to face it alone without us, how about considering how much that would have cost you? And please put at least some of that into this network, because we really do need your support to stay going. Everything here is user-funded, everything, including us. Nobody here draws a paycheck for this, all right? We survive, even though all the time we spent is pretty much doing research, helping with cases and things like that. We survive on either what we can do hourly to help people, which we don't charge a lot for that, and definitely not what a lawyer would charge for that. And it comes few and far between because we know how money's tight for everybody. But what we get is what keeps us going. And without it, we're done. We don't have the kind of sponsorships it takes like Alex has, and we don't peddle a lot of things on this show like everybody else out there does. We're not constantly harping on you to buy everything. But on times when the funds are short and the needs are great, we don't have a whole lot of choice. We survive because of you guys, just like you fight because of us. So think of that in a sense of value, and please treat us accordingly. We really could use it. All right, Randy, you got anything you want to add to that?
Well, just one complaint. You didn't mention Randy's Beer Fund.
If they want to give you a beer, let them come up to Dallas and buy you one.
Just think how much more coherent I would be. In truth, we take money out of our own pockets and put into this show to keep it going. It's of value to me to be here. And I hope it's of value to you. I hope that what we're producing is of value. We sit here and we speak into this microphone, and we can't see who we're talking to. So we don't get much feedback. And the best feedback we could get is some funds to help keep this show going. It lets us know that our efforts aren't wasted. Okay, enough of that. Back to the traffic code. Okay, where were we?
Well, we were discussing how this would be useful. The information itself would be useful as to what this statute argument over is it law or isn't it law, what's it going to do for us. And like I say, from my perspective, it puts them in a catch-22. But you were about to tell us some of the ways you think this would be useful in setting up an argument where we could really screw them over if they tried that.
Yeah, everything's about the money. It's always about the money. One of the things I keep saying, you'll never win your case simply because you have the law and the facts on your side. Forget that nonsense. That you'll only win your case if you have the politics on your side, and politics is always driven by money. So the only way, there would be a ruling that would change everything for every county, every municipality in the state of Texas. The enforcement of the traffic law is a major revenue source. And these guys do not want to lose this revenue source.
Yeah, not only is it a revenue source through all the stuff they make you pay for, the licensing and all that, but also the court costs, fines, fees, but it is their gateway to civil asset forfeiture, too. They use the traffic code to fabricate probable cause to make a traffic stop upon the public just so they can search your car for cash and everything else. If we win this, that goes away. That's an even bigger bite out of their financial enchilada.
So in order to be able to get a ruling in our favor, we have to find a way to cost them more money ruling against us. Because they rule against us, we're going to appeal. And then when we get to the appellate court, if the appellate court rules against us, we need a ruling that if they give the ruling against us, other lawyers can take that ruling and use it in ways that will do more harm than eliminating the traffic code or eliminating the application of the commercial traffic code to the public. So, how do we structure our claims? What other laws can we use our argument to undermine? This will take some digging, I'm sure. It takes a little creative thinking. But we always have to consider the money. We can't consider, we have to use the law as the way to get in the door, but in the end, it's about money. So where does more money move? Or where can we take some money out of somebody's pet projects by taking a ruling that we get here and that says that they can enforce these unconstitutional laws? This is kind of a difficult spot, because if a law is unconstitutional, then it's not enforceable. So what other laws do we have that politicians hate and would like to be rid of?
Well, the way I'm looking at this, if this is how they recodified the transportation code from Vernon's, this is how they recodified every code from Vernon's. And here's why I figure that's going to be a huge problem for them. Let's look at the way that the legislative process has to work. If they took and recodified Vernon's into the new code, what does that tell us about the existence of Vernon's as a reference?
Wait a minute, I didn't understand that question.
Okay, they took Vernon's, they rewrote Vernon's and made it into a single code. Everything on that particular subject. They took all of the transportation stuff from Vernon's, renumbered, reorganized, reworded, and relinked everything within a single code relating to transportation. Okay? And they did that through SB 971. So, once they recodified it from Vernon's, what happens to referencing Vernon's?
As far as I can tell, nothing.
I mean nothing. If they recodified it in the new code, they can't go back to Vernon's.
Well, Vernon's is not code, it's law.
Well, yeah,
is
it or isn't it?
Vernon's is code.
Right.
Vernon's is not the public law.
Correct. So the question becomes, what statutes are they now going to rely on when we get these declared unconstitutional? There won't be a code. They can't fall back on Vernon's because they superseded and repealed Vernon's when they reenacted it under this new code. So they can't fall back on Vernon's. The only thing they could fall back on is the actual underlying law that the codes themselves didn't change. They would have to go back to 1925 law itself and use that. That's all they would have, because we just nullified the codes.
Have to recodify. Recodify in accordance with the code.
In accordance with the Constitution to create the code, yes, because they would need to do the code, the recodification via a bill.
I said that wrong. Recodify in accordance with the underlying law.
Correct.
Public law.
And
so,
go ahead.
Is Vernon's considered to be an accurate codification of the
The ones that have the certification from the Secretary of State are. But like I say, those were codes, and they were superseded by the recodification. They were automatically repealed when they put in the new stuff. They would have had to have been. Or we could still be using them both, right?
Yeah, I don't see how we can.
All right, folks, y'all hang on, and we'll be right back to pick this up.
Attention foreign language students. Hit the books and get out those dictionaries. There's major good news about learning a second language. I'm Dr. Catherine Albrecht, back to tell you about a new study on bilingualism after this.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Learning a foreign language brings many benefits, but a new study has found a major long-term health benefit to bilingualism. It may delay the onset of Alzheimer's. Canadian researchers reviewed hospital records of patients with dementia. They discovered that bilingual people were diagnosed 3 to 4 years later than those who only spoke one language, even though they had less education and job status. Though brains of bilingual people still develop Alzheimer's, the scientists said, speaking another language better prepares their brains to compensate for the onset of the disease due to the enhanced brain networks they've developed. Maybe it's time to brush up on that French, n'est-ce pas? I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Beginning about chemtrails.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Yeah, who you want to chip? Who you take me from? Free Tolly? Who you want to chip? Me no free Tolly. You can't chip me. All I'm saying. Don't let them chip you in the morning, chip you in the evening. Put a chip in your body. And then when you go computer ready, you can't hide me from nobody. When me say, chip in your mom, chip in your daddy, chip in your grandpa.
Okay, we are back. Randy Kelton, Eddie Craig, and we kind of started this in the middle. If you don't listen to Eddie's show regularly, then you might not know precisely what Eddie's talking about. Eddie, will you explain why you're saying all of these codes are improper, what the legislature did to create this problem?
Well, the Texas Constitution under Article 3, Sections 29 through 38 contain very specific criteria for how public law in Texas must be made, who can make it, and every step they have to go through to make it. Now, 2 of those steps absolutely require that the bill be read on the floor of each house of the legislature and that open discussion be held on that bill. And these 2 things have to be done over 3 several days. Now, if you understand what that means, it means that the total time spent discussing and reading the bill must be at least 3 complete days. And this is any bill. Or the bill can be short enough to fit within that 3 several days. All right? But if the bill's longer, they have to get through it in 3 several days. The original bill, when it went through, was over 4,100 pages long. The output bill was over 2,100 pages long. Now, the question here is could they read between 700 and 1,300 plus pages per day for 3 several days? I don't think they could. In fact, they didn't even try. In the bill itself, they put in an emergency clause that said they were suspending the reading on the floor of each house. The emergency clause they used violates the Texas Constitution. The suspension that they did violates the Texas Constitution. They did not do anything to suspend this in compliance with Article 3, Section 62, which is the only section dealing with suspension of procedural rules, at least at that time. The only one that exists in addition to that now is a second clause that was added to Article 3, Section 32, turning the majority vote from a majority, 50.01%, into a 4/5 majority in order to get that suspension. But in either case, the bill was improperly suspended in its reading on the floor of each house, thus making it unconstitutional because another provision of Article 3, Section 32 says that no bill shall have the force of law unless those things have been done. So SB 971 is the bill that recodified the Vernon's Annotated Civil Statutes dealing with transportation into the existing transportation code, which has been constantly amended ever since. And those amendments created a secondary violation in addition to the unconstitutional passing, and that is amending the original purpose of the underlying law through recodification and rewriting of the statutes themselves. For instance, one of the definitions that was in existence back in 2011, when I did my InfoWars presentation, very clearly stated that the vehicle that was being defined was used for commercial purposes. The new version of that was redone in 2013 took out the words commercial. They are slowly but surely attempting to amend the verbiage to take away the implication of commercial activity from a code whose underlying law deals only with commercial activity. So there is no way on God's green earth that this could ever be considered constitutional under the Texas Constitution, but they're trying to keep it in place and treat it as if it is. And the lower courts are adamant about making sure it stays there, even to the point of violating your due process rights at every single turn to prevent this information from being made public. So that's where we're at.
So what is the emergency suspension statute that you say is unconstitutional?
It's not a statute. It's the actual verbiage they used in the bill itself. And in that bill, the verbiage essentially reads, due to the crowded conditions of the calendar of each house, creating, and the importance of this legislation creates an emergency, an imperative public necessity that the rule on the reading of a bill on the floor of each house be suspended, and it is so suspended. Well, the problem is Article 3, Section 62 of the Texas Constitution says there is only one way to declare an emergency clause for any bill other than an appropriations bill, which is handled under 49A. And under Section 62, the emergency can only exist under several conditions, the first and foremost of which is the emergency must be the result of disasters related to enemy attack. Then it goes on to say that in order to suspend the procedural rules, including Article 3, Section 32, the governor must sign a written proclamation. The chairman or the chairman of each house has to concur by signing that proclamation, and then there has to be a vote by the legislature of a majority, 4/5, in order to suspend the clauses under that emergency declaration. None of that happened. In 1995, Texas was not being attacked or invaded by anyone. There's no news articles, no news period, that we were under attack in 1995 when this emergency took place. A crowded calendar condition for the houses of the legislature is not a valid commercial or the constitutional emergency clause in any way, shape, or form.
So, is that particular law still in place, or has it been superseded?
When you say that law, are we talking about SB 971, the Transportation Code?
No, I'm talking about the law that allowed them to suspend the 3-day rule that was in effect in 1995.
In 1995, the 4/5 majority vote amendment had not been put in. That was put in 1999. Until 1999, the only thing for suspending any procedural rule was 49A in relation to appropriations bills. The rule could be suspended by 4/5 vote. Now you've got a 4/5 vote relating to the suspension of any bill. But the only clause in the entire thing other than 49A that says anything about an emergency relating to suspension of rules is Section 62 of Article 3. And everything in that is absolutely crystal clear as to what the requirements are for that emergency to exist. Because it says specifically that if a state of emergency such as that described by subsection A, then the rules mentioned in subsection B, which point to the rules up in 29 through 38, can be suspended.
What does 49 say?
49A basically has exactly the language of the emergency clause in question. It deals with imperative public necessity and a state of and the state of emergency relating to that public necessity. That is what's there for a fiscal bill, an appropriations bill. But SB 971 is not an appropriations bill, so it can't use the appropriations emergency clause to suspend.
That's what I was looking for.
And then they have another problem. If they try to argue that it is appropriations, then it still fails because all appropriations bills have to originate in the House. It would have had to be an HB 971. It's not. It's a Senate bill. So it fails muster at every constitutional juncture.
Wonderful. So that one is okay. That one's still in place.
They're all still in place.
Okay, so an attack on that one to get it ruled unconstitutional in its application.
In its entire existence. Not just its application, in its entire existence.
Then it would render any statute passed in accordance with that void as a matter of law if we could get that ruling.
Correct.
But that might be harder to get rid of than the transportation code because that'll flush a lot of law.
Yeah. Well, if every recodification of every code in Texas was done with the same emergency clause, they're going to have that problem across the board. And I think they're going to see that one coming once this argument gets out there.
Yeah.
All right, folks, we'll be right back.
Hello? Oh, man, in jail? Got busted, man? Oh, man, I'm broke, dude. Some things in this world I'll never understand. Some things I realize.
Okay, we are back. Randy Kelton, Eddie Craig, Rule of Law Radio, and we're talking about the unconstitutionality of the way that the legislature is currently passing bills through the House, all apparently under emergency provisions that do not comport with the Constitution. So we're looking for a way to get a wedge in there so we can, the likelihood of us getting the transportation code tossed is pretty slim. So what would be our first step in driving a wedge in this system that we may actually be able to get done?
Well, that's the question of the day. As I told you on break, they never met a code they didn't like. So I don't know how we're going to force the issue on any of them any more than the other. This one is extremely easy as far as having everything you need to prove it.
Do you have any feel for how the feds look at this?
Well, the problem is this being a challenge to an entire recodification. I don't know that this has ever been done anywhere. And so I really don't know if we have a frame of reference at the Fed or anywhere else for that.
Okay, now the fifth, we need to look at the circuits and see which circuit would be likely to rule in our favor. Then we need someone who's received a ticket in Texas who's out of that circuit. Then they could file in that circuit.
Yeah.
Some circuit that's a long way from Texas and won't tend to have what I'm doing now is thinking politically. And the more I do the show, the more I do the deal with the courts, the more I begin to understand how everything is political. We can't expect to win your case simply because you have the law and the facts on your side. We got to get the politics on our side. So where do we look for politics? One of the difficulties in looking for politics in this regard is if we get the traffic code trashed in Texas, we're likely to get it trashed everywhere else unless we choose our claim very carefully in a way that only applies to Texas. And it seems you have one. Because if the federal court rules that that this emergency provision that was used was not properly used, that won't affect anything but Texas.
Right.
So if we can find a circuit that may be more amenable to our argument and they can render a ruling and it won't affect their state or the states that they're in around where all their friends and buddies are, we at least have a better option at getting a ruling. Then how do we make it easy for the judge to rule in our favor? Because we know judges do not like hard cases. They especially don't like to make rulings that changes the world as they know it. So is there something an ancillary, but close enough that we could get an initial ruling on.
Well, that's the rub. I don't see this coming down easy any way we do it. In fact, the plan of attack I have for this specifically avoids that level of confrontation for a while until we have enough dismissals and everything under our belt to have a scattering of people across the state that could then join up to go after this issue as a whole.
Well, what I'm thinking is, let's get somebody outside the state. I know we got that guy in Pennsylvania that was down here and got a ticket. No, he got a ticket.
No, that's Arizona.
Yeah, that's Arizona. So we need somebody who is some people from out of state that's gotten tickets here that might be willing to take a suit in their circuit. That's one degree of separation, but everything you're arguing so far is so heavy that I can't see a way to get a ruling because the courts are corrupt. They're absolutely corrupt.
Yeah, unfortunately, in this particular case, they would have to make their corruption absolutely public to get away with this. Because the way that I'm writing this, the opinion they would have to make would say why every single one of these constitutional provisions is no longer valid. Even though they're still in the Constitution, there's no amendments to them, there's no eradicating repeals to them, none of that. They're going to have to try to say that none of them matter. In which case, what they're trying to say is the Constitution doesn't matter. And I think at this point, that would be extremely dangerous, even for them.
Yes. My concern is that we get a bogus ruling in a district court, and we appeal to the state circuits, and the state circuits are going to rule against us. We file in the federal court in Texas, and they're going to rule against us. We just have to expect it. And then it'll go to the fifth, which, in my opinion, may be one of the most corrupt circuits in the country.
Well, I'm not arguing with you there.
They're absolutely going to rule against us, and then the Supreme will not pick it up. That's the Supreme's answer to difficult questions, is they just ignore them.
Right.
So where do we find the clout we need? I know one thing, I have a issue. I have someone who works for me that got a ticket in Lakeside, Texas, tiny little town, about 1,300 people. And she went to court with my challenge to subject matter jurisdiction, and it upset the judge and prosecutor to the point that they threw me and David, the guy I was with, out of the courtroom because we were possible witnesses. They asked us if we would possibly be called as a witness, and we both said we have no personal knowledge of anything relating to this case. And the prosecutor just kept on, is there any possibility that you could be called as a witness? Not that I know of. He said, if I called you as a witness, would you object? I said, I'd love to get up there. So he invoked the rule and threw us out. And then she went in, they ruled against her, and they told her she had to pay the fine right there. She said, well, I need to talk to my friends out there. I don't have enough money. Well, you should have thought of that earlier. They threw her in jail for 72 hours. Contempt of court. That might be a good one because it's so outrageous. The next morning, I go in with a habeas, and I ask them for the judge's bar card and the prosecutor's bar card because I needed it, and the order,
the commitment order,
order to incarcerate her. Yeah, and they didn't have it, so I told them I needed it for my habeas. So I couldn't get that because they said I'd have to put in an information request and blah blah blah. So I went down to the county courthouse, and I raised so much cane. I went into a court, the only court I could find in session, called the bailiff over, told him that I had a habeas for the judge, and to go tell the judge. He goes, walks up next to the bench, but don't say anything. So I stood up and said, Your Honor, my name is Randall Kelton. I have business with this court to supersede any business now before this court. So he was not happy about that. Well, what are you doing in my courtroom? I said, I'm here with a habeas. Well, I'm not going to hear it. So, Mr. Bailiff, I need you to arrest the judge. And the judge said, Mr. Bailey, throw him out of my courtroom. And they did. So I went around every other court, went to the clerk and asked for every judge that was in that day to contact them and see which one would take my habeas. The one that normally heard habeas was out for the day. And I said, well, find somebody else. I don't care who does it. I just made a nuisance of myself. And it turned out I didn't need to, because as soon as I walked out of the Lakeside City Hall, they called down and had Tony let out of jail. So while I'm stirring up all this stink, anyway, they got her out of there quickly when I asked for the commitment order. I finally got one, but I'm sure they backdated it, because I went to the police department and asked them for one. They didn't have one. But anyway, they arrested her for not paying the fine immediately when you got 10 days by statute.
Yeah.
So this would probably be a good one to sue, because they only got 1,300 people. They don't have deep pockets.
Well, maybe.
They can't hire the big high-powered lawyers to fight us. Anyway, it's the politics, all about the money. Randy Kelton, Rule of Law Radio. We'll be back tomorrow night for our 4-hour info marathon. And when the show's over, go take a look at our sponsors and look at the gun giveaway and think about what we're worth to you and see if we can't return a little of that back to us so we can stay on the air and keep our quality up. This is Randy Kelton, Rule of Law Radio. Thank you all for listening, and good night.
Dangerous.